As you're no doubt aware, at the back end of the summer, the FCA published its proposals in relation to which provisions within the Consumer Credit Act should be retained. The time for discussion and responses in relation to this interim report has now passed, and I thought it would be worth spending a bit of time highlighting some of the views expressed and setting out the next steps. By the 1st of April next year, the FCA must report to the HM Treasury on its proposals for the CCA. The review must consider whether the repeal of the CCA would adversely affect the proportionate degree of protection for consumers. Specifically, the FCA was asked to consider which provisions of the CCA could be replaced by FCA rules or guidance under FSMA, using the guiding principles that a burden or restriction in relation to the carrying out of an activity should be proportionate to its benefits. This is important because the interim report evidences that this has not happened. In respect of each of the requirements of the CCA that provide protections, with one exception, the FCA have failed to consider the burden on the industry and instead concluded wholesale that where a provision cannot be replicated under the existing FSMA rules, that it would automatically lead to a reduction in consumer protection, without considering whether there's a better way to achieve the same outcome. The proportionality of benefit versus burden is simply not discussed, other than in relation to the information requirements. Nor has there been any consideration of the practical applications of the provisions. For example, in relation to time orders, the FCA appear to have simply assumed that the removal of the consumer right would lead to a reduction in consumer protection without identifying whether these are actually used by consumers at all. This review is a great opportunity to simplify the current fragmented position and consider what regulation of the consumer credit market should look like in the 21st century. However, this isn't where the regulator started from. They're focusing on the original requirements nearly 50 years ago. Everyone involved in the industry is aware of the complexity that surrounds the Consumer Credit Act, largely arising by the way it's evolved over years, layering numerous regulations over statutory provisions, then EU legislation, and then latterly FSMA and CONC. This complexity makes it a difficult area of law to comply with. And when you combine this complexity with the draconian consequences of failing to comply, this impacts development of products and stifles innovation. Many of those who have been involved in the roundtable discussions and provided responses have shared this view clearly with the regulator and encouraged the regulator to spend more time looking at the overall customer journey in an attempt to create a balanced and proportionate consumer protection legislative framework that truly balances consumer protection with industry burdens. One area where there is some hope is in relation to the information requirements. Whilst the FCA have taken the view that the natural automatic sanctions of unenforceability and the penalty of disentitled interest give rise to self-policing by the industry, they do go on to acknowledge that some of these provisions are disproportionate on their impact in lenders. And as a consequence, they are looking at the materiality of the harm caused to customers as part of their proposal to rewrite these into the handbook. This proposal is naturally welcomed. However, they will give rise to some practical difficulties with the courts having to interpret CONC rules. There is generally concern that insufficient time and resources have been allocated to the undertaking of this review. Furthermore, with Brexit, it's highly unlikely that further resources will be forthcoming or further time provided to undertake the review required. Naturally, this is disappointing for the industry, and we continue to push to ensure that an extended time framework will allow the review to be undertaken. The next step is for the FCA to consider both the written submissions and the output of the roundtable discussions to draft its final report, which, as I say, needs to be submitted before the 1st of April next year. We hope that the FCA will consider the proposals and look to extend the time so that we can undertake a proper review of these requirements to ensure that the right outcome is achieved.